Hi, everyone. Welcome. Thank you for joining us. My name is Smadar Nat. I'm a principal and the head of the Israel desk at Prager Metis CPAs. My co-host and moderator is David Posalski, attorney at Gearhart Law. Our discussion focus today will be on some of the things that foreign companies and startups that want to expand their operations into the US market should know or consider. Joining us today are very knowledgeable experts on the subject. Our panelists are Oded Omer, co-founder and CEO of Wasteless Inc., Fernando Lopez, International Tax Director at Prager Metis CPAs, and Ed Rigby, ex-partner at Prager Metis CPAs. Just a few items before we begin. David, are we going to be muting everyone to minimize the background noise?
Yes,
or
we're definitely going to be doing that.
Okay, so your microphones will be muted, but we would love to hear your questions. So please, if you have questions or comments, type them in the chat, and we will.
I just muted you, Smadar. Hold on one second. Hold on.
Okay, I think I unmuted myself.
Yeah, you're good.
Okay. All right, so I was just saying that if you have questions, please type them in the chat. We will reserve time at the end of the discussion for questions, but also try to address questions during if possible. The webinar is being recorded, so it will be available on our website for later viewing. And that's about it. David, please take it away.
Great. Welcome, everybody. So as you heard, my name is David Posalski. I'm an intellectual property attorney. I'm based most of the time in Tel Aviv, Israel, where I'm actually taking this call. I split my time between here and New Jersey, where Gearhart Law is. And we're basically an intellectual property boutique helping startups emerge into the United States from different countries. I'm excited about this presentation. I'm excited about this cooperation with Prager. I think you're going to learn a lot. We're kind of going to get right down to it and start because we definitely have some things we want to cover. But again, if you have any questions, maybe chat them. We're monitoring that. We'd love to see you on video if you want to ask it personally, but definitely chat us first if you have a question. This is meant to be a kind of an informal discussion. So if you have any thoughts on a question or an answer, please let us know. So I'm going to get right down to it. I'm going to start with Ed. And Ed, you know, we had a small little bio about you. So maybe the first time any of you speak, maybe you can just kind of fill in the audience as to who you are and what you do. But I think the question will elicit that. So the main question, like what states in the United States, like we have companies on the phone based in US, Israel, other countries looking to expand into the US market. We'll focus on that for now. What are they looking for exactly? Like what states are the most advantageous? Everyone talks about Delaware or New York or Silicon Valley, California. From your perspective and your experience, what states are probably the most advantageous for a company to be creating a US entity in order to emerge into that market?
Well, thank you, David. And, you know, to answer that question, I advise private business owners. We're a national firm here at Prager Metis. And so we have domestic clients certainly throughout the country. And we also deal with non-US persons looking to invest in the US market. And actually, I work very closely with my colleague, Fernando Lopez, when we talk about what's called cross-border tax planning, which Fernando is certainly an expert on, we'll get into. But to answer the question about which states, people ask about Delaware. And Delaware, it's really not so much from a tax standpoint, but from a legal standpoint. Attorneys feel very comfortable incorporating or forming an entity under Delaware law, the court system. So Delaware tends to be a good place to form your business for various non-tax reasons. Now, to answer the question, I mean, the states vary. It's funny, about a year ago, I was heading down to Washington with a New Jersey contingency with various business leaders, and we had met with our governmental officials down in Washington, D.C., and I was interviewed on the train. And right at that time, the governor's budget had come out proposing some tax increases. And when people think of New Jersey, you know, it's a high tax, certainly high tax state. The governor kind of looks towards the California model for taxation. There was some nuances, some new rules put in for corporations and combined reporting, but New York, California, New Jersey, certainly higher taxes than, say, a state like Florida or Arizona. You know, there are states that may have no corporate income tax, but they'll have a sales tax. But one of the things you have to look at, I think, from a practical standpoint is, you know, your market. I mean, people say, well, why should I do business in New Jersey? And not to just promote New Jersey, but, you know, you have a very educated workforce, quality of life. When you're doing business, you have employees working for you, or you want to live in a certain area. I mean, New Jersey has a lot to offer, but also the market. Yeah, it's a good market. So states like California, New York, you also have to look at your market too, and not just focus in on tax matters.
Yeah, that's a good point, and it's probably a good segue to ask something of Fernando. So there definitely are a lot of companies that look to launch in the United States and probably haven't set up an entity, right? They're looking to market themselves, and you know, they're looking to see if they maybe have enough, you know, touches with the state or the states in order to set up an entity. So Fernando, to you, can you market your products, your services in the United States without setting up a legal entity, right? Without choosing a state to set up a legal entity? And if you do that, what are the tax issues, or are there any unforeseen issues that folks should know? What do you think? You have to unmute yourself, Fernando. I'll keep you unmuted, by the way, Fernando. I'll keep all the speakers.
Well, that's a good question, and one that anyone thinking of marketing or selling in the US should consider. Before setting up anything here, is it possible to just market from your home country outside the US? And it is possible. You know, you can, for example, just export your products. And if you're going to do that, then you need to identify someone on this side, a distributor that you will sell to, and that will handle, you know, on distributing to retailers. If you're doing services, then maybe it's a little more complicated. If it's not online, then what you could do theoretically is to hire independent contractors in the US who would provide the services here on behalf of the foreign company. You know, when you talk about, you know, the e-commerce, products and services can be provided online. And in that case, it's very possible to market your online products or services via the web without creating a taxable presence. And now, you know, since you mentioned what are the risks, if you're selling online, as long as you keep a server outside the US and you don't have agents in the US drumming up sales or finalizing contracts, it shouldn't create a taxable presence for your foreign entity. If you have independent contractors here, you have to be careful also that they will not be signing contracts on behalf of the foreign company. But otherwise, as long as you know, paper the employment or the independent contractor agreement properly, you should be able to insulate the foreign company from having a US taxable presence. And really every company thinking about coming into the US should really start with that that approach? Is it possible to just do it from our foreign country without setting up a legal entity here?
Yeah, that's a good point. I think most companies that are coming into the United States don't appreciate that, you know, if you have to hire someone in the United States to do something for you, how you hire that person, as you were just saying, whether they're an independent contractor or an employee under the law, begins to, like, those labels begin to trigger certain, what we call touches, right? That may require you to set up a foreign entity in order to take advantage of taxes, or, you know, yes, I think that's a great point. I don't know if you have anything further on that, but like the type of the type of workers you will employ when you expand into a specific country can dictate so much of what you should do next.
You know, it's interesting, David, if I may just to add a comment, Fernando, this permanent establishment issue, whether or not you're doing business in the U.S. based on your particular activities, but at the state level too, the states have various taxes, which I'm sure we'll get into. But this issue of doing business in a particular state, there's different rules for sales tax purposes, corporate income tax purposes, and although not quite the same as the permanent establishment rules, but we call it nexus to it. So
right,
you have
nexus, right? I keep calling it touch, but it's nexus. Yes.
a state. So, you know, again, it's somewhat similar, but you know, the states all have somewhat different rules.
Yeah. So from a federal perspective, you may be able to market from the foreign country into the U.S. without establishing a presence here. But from a state and local level, if you're doing sales here or providing services, even remotely, you may trigger a state tax liability.
Absolutely. California is an example. If you have sales over a certain threshold, even though you don't even step foot in the state of California, you could be on the hook for various taxes. Sales tax, there was a U.S. Supreme Court case called Wayfair, where the Supreme Court ruled in favor of the taxing authorities. New Jersey has a Wayfair rule now, where if you have sales over a certain threshold, you are deemed to have an economic presence in the state. It's requiring the company to register for sales tax purposes.
Right.
Even presence in the state.
So I want to move to Oded. So Oded, you are based in Israel, and you have you started out as a Israeli company, and I'd love for you to kind of let people know what is Wasteless, and you know, you have expanded into the U.S. market. So if you can talk a little bit about what Wasteless is and what was the driving force behind you coming into the United States.
All right. Sure, David. So, so Oded Omer from Wasteless, mainly Europe and specific countries in Europe. So we spent some time in New York only to understand that on early 2017, there was no traction for food waste prevention, not at all. Okay, so we took the company and we opened our first subsidiary, not in the US, in Europe, okay? So in the Netherlands, and then we got investment in the Netherlands. Now, on early 2019, we realized that we have to check the market again and the market fit again. And then we saw that okay, there is good traction for food waste, and therefore we should go and chase the U.S. market. But the U.S. market is huge, and we started to raise money for that purpose. Okay, so that's the story. We started with the fundraising, and we realized from from VCs that we are recognized. We had good name in Europe, and we still do, but we were recognized as a Dutch company, okay, not Israeli company, because VCs do invest in Israeli companies, And we heard again and again things like, okay, but where the hell is Europe? You know, you work in Italy. Where is Italy? Italy is a nice place for vacation. And, you know, we visited Palo Alto and eventually we heard, listen, you're not located here. You're not working here. You don't have offices or employees. Even, you know, you don't have American phone. So if you want to raise money here, you should be here. Okay, so that was our trigger. Okay, now it shouldn't be the case, and it doesn't fit everyone, right? We are B2B company, and as such, we have to meet retailers, we have to gain some trust, and we must have local offices, let's say, in places where the retail tech is, which is usually California, Georgia, and Illinois. Okay, so I talked with David at the time. We've decided to open entity. We've decided to go for, you know, the usual entity, which is Delaware, and we also decided for soft launch in New York. And why? There is no retail tech in New York, right? So just for soft landing. We know the city, it is nice, you're located in Chelsea, so it's okay, okay? And that was the journey, let's say the first couple of months of our journey. Of course, the following, you know, a few months down the road, we realized that okay, we should move to Atlanta, we should move to California, where most of the headquarters are. Okay, and then we realized other things such as taxation. Okay, so every state has its own taxation when it comes to employees, and we have employees. Okay, we had 3 states, so 3 different taxation system, and so on. You know.
Yeah, it's definitely something to consider. I think people coming into the United States, we're this region made up of like 50 unique states with sometimes very unique requirements. And to that point, Ed, what do you think? Because I think Oded touched on a lot of the stuff that you and Fernando were just talking about, but I think the biggest thing is like, okay, I'm starting a US entity, I'm choosing Delaware, I'm choosing a C corp. I don't even think people understand the differences. I mean, yeah, there are, between LLC, C corp. Like, I don't know if you have any, if you or Fernando have any.
Let's shed some light on that. Now, this is interesting because Fernando, you and I, we talk pretty regularly with non-US investors, and if I am speaking to somebody, one of the first people I'm going to reach out to is you, and we're going to talk about cross-border planning. In the U.S., there's a interesting type of entity called a subchapter S corporation or an S corporation. Typically, non-U.S. persons aren't going to be able to utilize that because the tax rules say that you have to be a U.S. person, U.S. citizen, in order to be an investor. The S corporation would be similar to a partnership where the net income or loss would flow through to the owners and be taxed on their personal returns. Typically, the entity itself is not subject to tax. There's some nuances with that, and some states apply an entity tax. But years ago, partnerships, again, they are considered to be pass-through entities, so that income or loss of the partnership would flow through to the owners. But one of the problems with partnerships is that you don't have liability protection. So in the 1990s, at least here in New Jersey, mid to late 90s, limited liability companies started to come into play. So states began passing limited liability company acts. And the benefit there is that the LLC owner has liability or asset protection, like a shareholder in a corporation enjoys. But the LLC, if it's taxed as a partnership, the entity doesn't pay taxes. The net income or loss would pass through to the owners. So it's taxed as a partnership unless you elect to treat it as a corporation. But the owners have the benefit of liability protection. But one of the things, and just to kind of, just to put this thought on the table, I think when we're looking at the type of entity, and Fernando, you could certainly jump in on this. The first question we're going to ask is there an anticipation that we're going to have losses, or are we going to have income? And if we have income expected in the U.S. and the company may have, or the owners may have, a tax consequence in their foreign jurisdiction, we want to make sure that we're taking advantage of foreign tax credits. If there's income, or if there's losses, do we want to pass those losses back to the owner? So determining whether we're going to set it up as a C corporation, which the entity pays taxes as a C corporation, or as a pass-through entity, depends on whether or not we have income or losses. Fernando, your thoughts?
Yeah, so today, well, actually, I'll go back. Prior to, say, 1986, most U.S. business activity was conducted through corporations. And I believe it was in 86, the tax law raised the corporate rate to 35, and the individual rate was lower than that. So after 86, most people chose partnerships for their business activity. And the reason for that is that if you have a partnership or an LLC that's a flow through, or an S corp, it's only taxed once at the owner level, whereas a corp was taxed twice, first at the corporate level and then at the shareholder level. So, you know, right up to tax reform in 2017, most business activity was conducted via partnerships to take advantage of lower tax rates. 2017 lowered the corporate rate from 35 to 21. So all of a sudden corporations became more attractive. And so that's one consideration. Another is you want to integrate whatever entity you choose in the US with the ownership structure outside the US. For example, if you're an individual outside the US and you form a US corporation, the corporation will pay 21% on $100. It will distribute a dividend, and most individuals in foreign countries will pay tax at their individual rate, whatever country they're in, and they will not get a foreign tax credit for the corporate tax paid in the US. So that off the bat is an awful cross-border structure. You would not want to be an individual generally and form a US corp, because you're not going to get a foreign tax credit. And that's why in that case, you might use an LLC as a flow through, a partnership. So those are considerations to think of. You want to obviously take advantage of the entity that's going to provide a low rate in the US, but you also need to integrate it with the foreign ownership to make sure that you get foreign tax credits, you relieve double taxation.
You know, Fernando.
Yeah, go for it. Go for it.
Yeah, just to add a note with the great history on the 1986 Tax Reform Act, one of the key items also with respect to corporations is that when a corporation distributes out appreciated property to its shareholders, either in a current distribution or in a liquidation, it triggers a gain at the corporate level, and that applies also to S corporations. So that double tax in a C corp context. I had an issue come up this past week with an S corporation looking to distribute appreciated property out, and it triggers a gain. That's why when people ask, I'm thinking of investing in real estate. Real estate is typically going to be placed in either an LLC tax as a partnership or a partnership. And if there's a reason at some point based on an exit strategy to distribute that property out under partnership law, generally speaking, it doesn't trigger that entity level gain that a corporate entity would be. So that's a big difference with a corporate structure as well.
Fernando, just back to you for a second, because I want to know if there's any other kind of like unforeseen issues that folks that or companies that are looking to expand in the United States are kind of not seeing, right? What are the blind spots here? I mean, for sure, the right entity, what state, there's some tax issues. Anything else that you can maybe kind of expand on from your experience?
Well, just very obvious is that you all of a sudden are operating cross-border, so you have two tax regimes to consider. And you have to integrate both of them to achieve tax efficiency. And that may involve leveraging treaties. It may involve using a holding company in a different location than your home country in order to take advantage of a treaty. Other things to think about are cross-border transactions. Is the foreign entity going to sell to the US entity, which will turn around and sell? Or will the US entity be kind of a sales and marketing or a limited risk distributor? What level of activity are you going to give to the US entity is a consideration. That will drive some of the decisions about type of entity. And also related to the intercompany transactions, you need to think about transfer pricing, which basically all OECD countries have transfer pricing rules, which basically requires intercompany transactions between two related companies to be done at arm's length. And, you can look at that as a burden, but it's also possible to look at that as a good strategic tool that will permit you to generate most of your income in a low tax jurisdiction and most of the expenses in the high tax. So intercompany transactions, strategizing about those, what level of activity will occur in each jurisdiction, and the transfer price are really important. And like I said, it may be the case in some circumstances that you will want to consider a holding company in a new jurisdiction to hold the US entity, especially if it will provide, the ability to use a treaty.
So,
Fernando,
yeah, go for it.
Yeah, just quick to add a quick comment, Fernando. One of the things we talk about in planning is intellectual property. So if they have trademarks, R&D, if they have client-based intangibles, what's the best jurisdiction to house them? And you do a great job at looking at the whole structure. The U.S. and the foreign. To maximize tax benefits.
That's a good point. The IP obviously is a big important asset in many businesses, and figuring out the best ownership, R&D and ownership and management of the IP is really important. It may be that the country in which it's developed is the best place to keep it, but most of the time it won't necessarily be. And ideally, you want the IP to be owned from the beginning in a low tax jurisdiction, and that way it can license it to related or unrelated parties and generate the income at a low tax rate. But if it hasn't been developed in a low tax country, there's opportunities nonetheless to move it to a low tax country and to take advantage of generating income related to that intellectual property at a low rate. So, again, that's a major asset for most companies. It's a big revenue generator, and it's really important to figure out where you want to own and manage that asset from.
Ojed, did you want to? You were agreeing with a lot that they said. Go for it, please.
I have a remark. When it relates to IP, many of the Israeli companies are or were invested by the innovation authorities of Israel, meaning you cannot take the IP, okay, to another company, nor to any of your subsidiaries. So you are stuck. So I guess the main practice here will be just to leave the IP in the main company. That's if you have grants from the innovation authorities in Israel, or if you have grants in from Horizon 2020 in Europe, which are typically larger, still you have to maintain the IP in the same country you developed it, okay? Or you got the grant in. Mhm.
So Oded, I actually saw you also uh, uh, nodding in agreement when Fernando was talking about some of the cross-border stuff. So you have three entities. And so can you talk a
Yes.
little bit, about the relationship with each? And I know, and I'm bringing this up specifically because Sivan had a comment where, you know, she's in Israel, but
Yeah.
there's this US customer facing part that's happening. So there's development in Israel, but US facing in here. So just you may have the same type of situation, but maybe you can talk a little bit about the relationship between the three entities and how it kind of works out.
Yes. So first, every subsidiary is totally separate, okay, in Wasteless, and we set transfer prices, okay, and there is a rate. So actually, um, the subsidiary is paying for it's not a management fee, okay, but we charge some management fee, okay, in order to reduce tax. That's in the Netherlands, and since we don't have income yet from the US, I don't know what to tell you. Okay, but for sure we have transfer prices, okay, so we set the mechanism to do that, but we are not generating revenues outside of Europe, not yet at least.
Got it. So you don't have any kind of intercompany licenses or agreements in place as of now.
We have with the Dutch company, not yet with the US. You know, it's very new.
Yeah, yeah. You know, I
Yes.
think the intellectual property issue. I didn't realize that if you got a grant from the Israel Innovation Authority, that the IP had to be in the entity that's in
Of
Israel.
course, because
I didn't realize
of
that.
course, and that's a trap. And I stepped into this trap when I sold one of the companies in 2012, right? So we sold the company, and we had it was, you know, two companies before Wasteless, okay, and we had to pay to the innovation authorities. Their name was Office of Chief Scientist, whatever, OCS. We had to pay six times the money they invested. Okay, so it's up to 6x. Okay, if you take the IP outside of Israel, but there is a formula, so you can dilute them, but it takes time. You can maintain 70% of the R&D power in Israel and still take some. This is very, very complicated subject here.
So Oded, so just so everybody knows, Wasteless does have, you know, patents and trademarks in the United States in different countries.
No, we have in Israel, we have 4 patents and 2 trademarks, and
And
our .com domain, which I still owe you for.
right, but you also have, but you also have U.S. patents, is what I'm trying to say. But I'm just
Yes,
curious,
but
what has
submitted from here and held by the mother company,
got
right?
it? And so, what has been the response by investors? Because you have investors. What has been the response by investors to the fact that the IP is owned by an Israeli company, or it doesn't matter to them?
That's not a problem. The IP and the R&D is very common to have it in Tel Aviv. You know, a few thousand startups here. It's very common. It's not a challenge at all. And mostly many investors today, these days, they look at patents and they say, yeah, that's like, you know, it's like a purple curtain. That's a nice scenery, but not more than that. Maybe it is defensive. I don't know. You know, I believe in patents. I still submit many.
Yes, totally. So I probably won't, this will not be all about intellectual property. I want to go back to Ed. So you launch into the United States, you pick your entity, you set up shop, you start hiring employees, maybe not. You're definitely operating at a loss for sure. What, in the first few years, what, if any, benefits are there in the United States for such losses, and how does that work?
Well, in answering that, one issue would be whether or not the entity was set up as a pass-through here in the U.S. So if there's losses early on, those losses would pass back to the owners. Within the U.S., we had in response to the pandemic, we have what was called the CARES Act that came out towards the end of March. And certainly there was a big emphasis on small business administration lending program called the Paycheck Protection Program, but there was a number of tax issues in there dealing with the timing and use of net operating losses. Generally speaking, the major tax act at the end of 2017 called the Tax Cuts and Jobs Act that did away with the ability to carry losses back to prior tax years. The CARES Act says that for 2018, 19, and 20, there's the ability now to carry the losses back to 5 previous years. And Fernando had mentioned before about the C corporation tax rate. It was 35%, and starting in 2018, it dropped down to 21%. So you think about it, if you have a net operating loss in 2018, you could file an amended tax return and carry that loss back to tax years where the tax rate was up to 35%. So the takeaway there is that we have net operating loss rules to possibly carry the losses back or forward indefinitely. The CARES Act modified the rules that you can now apply for 2018, 19, and 20, utilizing the loss against 100% of your taxable income, where the Tax Cuts and Jobs Act at the end of 2017 said that you can only apply the net operating loss up to 80% of taxable income. So that's in the corporate setting. People ask, Ed, what about individual owners? Well, the individual owner for U.S. purposes could also carry those net operating losses back to prior years as well. But again, losses early on, we want to structure it so that if it's advantageous to flow the losses back to the owners, or if it's set up as a corporation here. Remember, Fernando pointed out about the foreign tax credit issue. But if you are a corporate entity, you can utilize those losses, again, to carry back or forward, depending on the circumstances.
Great, thank you, Ed. Fernando, just kind of touching on a little bit of what Oded said about having 3 entities. Do you ever envision a situation where it's most advantageous for a foreign company to set up a U.S. company as the kind of the global owner of the business and everything? Is there any sort of situation where that would be most beneficial?
Yeah, there's a couple of considerations that would drive a foreign business or business people to form the U.S. company as the holding company. One is just to raise financing. Obviously there's a lot of capital here. There's a lot of VCs, a lot of private equity funds, and many times, but not necessarily always, they may prefer to invest in a US-based company that is the parent. Another reason, and I'll probably give 3 or 4, another reason is our corporate rate is very competitive with most countries now. 21% corporate rate is really good. If you're gonna manufacture in the US, the tax reform of 2017 provided the opportunity to write off in the first year most of the investment in tangible depreciable assets. So that's a big benefit. Another benefit is that, right now, Odette has 3 subsidiaries in various countries. And when they start generating income, they're going to be taxed at the local corporate rates. And my thought is that generally that's going to be close to 20 or maybe even up to 30 in some cases. If you set up a US corporation and serve foreign customers from the US corporation, and that could mean selling products, exporting products, it could mean providing services to non-US customers, it could mean licensing IP from the US to foreign entities. The tax reform provided a reduced corporate rate of 13.125% on that. Now that's a fantastic rate and certainly should be considered for anyone who is thinking about setting up in the US. If you're going to market to the US market, then you might want to also think about using the US entity to market outside the US because it benefits from that low rate. So I think those are the main considerations with respect to choosing the US as a holding company, as a parent for a group.
Oh, did you want to comment on that a little bit?
No, so in our case, we got a demand in early 2018 to flip the mother company and the subsidiary. At the time, we had only the Dutch entity, but I guess the rules are the same here. Okay, so you have OECD countries, and you can flip the holding company and the subsidiary, but it has, here in Israel at least, it has severe implications tax-wise, okay? And also because of the IP, we couldn't do that, and we had to refuse to some good opportunities and good investment at the time in Europe. Now it's not the case anymore because we have our structure. We are not going to change it. But I heard it before. When we only thought of Wasteless, I heard my lawyer actually said, you should consider American company. So the mother company will be in the US. At the time, I don't know why, it just didn't happen. And after that, you cannot fix it. The moment the innovation authorities are in, you have IP, any flip will have severe taxation issues.
Yeah, and I recognize that, but I guess I should clarify that to take advantage of that 13.125 rate, the US corporation doesn't necessarily need to be the parent. It could be the subsidiary. And what it could—
But charging there, that's okay. And keep the money there, by the way.
Yeah.
That's okay. This is what we do in Europe. We just keep the money there.
So by the way, so if anybody has any questions, definitely let us know. Smadar has a question. Smadar, maybe you can ask it live if you can. I mean, you wrote it, but it would be great to hear you live.
Yes, sure, of course. Yeah. So for Odette, it's actually a 2-part question. Is it necessary for the founders to physically move to the US for a period of time when they establish operations in the United States? And the second part is, how do you put together a team to conduct and oversee the day-to-day operations?
Okay, that's a 2 different questions. The first one is no, okay? Yes, I moved there for a while, but I did not have intention to stay there. So in our case, at least B2B, I believe that in order to sell to Americans, you should be American, and therefore we are the general manager there, okay? And in New York, currently in Atlanta, and so you don't have to move to the US in order to have US entity. Okay, that's first. And what was the second one about the team?
Yeah, how do you put together a team to conduct and oversee the day-to-day operations when you're not living in the States?
So in our case, it was very simple. You know, we had general manager that worked with us for a few years before that, okay, and we put the task on his very wide shoulders, and I was there to help him, but pretty much he took it all on himself. Okay.
So,
Yes, but again, we worked together 4 years before, also in another company. Okay.
so the general manager was based in the United States?
Yes, you know, yes,
He's
of
American.
course, he's from Atlanta.
Got it. And so Ed, to you, like just to kind of get on, stay on that employment, hiring, what are some considerations in hiring a US employee, kind of like what Oded did? Like, what are some of the things we're not seeing?
Well, I think first of all, from a non-tax standpoint, a big issue here in the U.S. At the state level is the classification of workers. Here in New Jersey, it's the New Jersey Department of Labor, New York as well. They have different set of rules for classification. The question is the person a contractor, in other words, a self-employed person, or are they your employees? And this classification could lead towards to penalties. So if the person is under your direction and control, typically they would be an employee. A self-employed or independent contractor would be free to provide services to other businesses. They're not just working for you exclusively. So making sure that you identify properly the classification. And if they're employees, there's payroll tax withholding, there's typically contributions for unemployment insurance, disability insurance. So that's a big thing. And then switching into income tax planning, you want to make sure, and especially with the COVID-19 crisis, we have people working remotely throughout the country. Let's say, for example, if I here working from my home in New Jersey, but if I worked for a New York employer, New York currently would say, well, you're just working from home for the convenience of the employer. So I would be still responsible for New York taxes. Alternatively, I'm working with a client that they use people working remotely out of their homes. They're providing certain services. They have company equipment, laptops, et cetera. The question then becomes, does that create a taxable presence for the employer in these other states? So that state tax nexus is a big thing.
Awesome, thank you. So listen, did anybody have any questions? I'll throw it out one more time live. Anybody have any live questions?
David, I just want to ask one more question to either Ed or Fernando. If you do decide to bring a team from your country of origin to help with operations or kind of run the operation, what are some of the rules for non-resident employees, and also does the type of visa that they come with impact, what kind of tax they'll be subject to?
It's a good question. Who's taking it?
Yeah, well, I will start. So the question then becomes, if they're a non-resident, typically you're allowed to be here in the U.S. A certain level of days, and if you're on a temporary visa, again, I think Fernando, that gets into the tax treaties, right, with the respective countries. But you have to look at how long are they here for, and whether or not, generally, if you're here for more than 183 days, I believe you have a taxable presence in the U.S. for U.S. tax purposes.
That's right. The taxation in the U.S. is going to depend on the amount of days here. And, in addition to considering their personal taxation, you have to consider whether they will create a taxable presence for the foreign company. If they come to the U.S. and they're being paid by the foreign company, then they'll be deemed agents of the foreign company, and their activities here could create a taxable presence for the foreign company. So typically what's done is they're either put on the US company payroll, or they enter the foreign entity and the U.S. entity enter into a secondment arrangement, whereby they still nominally remain employees of the foreign entity, but it seconds them to the U.S., gives the U.S. entity the right to oversee their day-to-day operations, their day-to-day activities, and the foreign entity invoices the U.S. entity for providing these employees. That's a secondment arrangement, and it's very commonly used to avoid creating a taxable presence for a foreign company when it needs to deploy personnel into the U.S.
It's an interesting issue too, if you're a U.S. citizen or U.S. resident here, too, the concept of being taxed on worldwide income, and that's when you get into, so wherever the income is earned. For example, we see where U.S. expatriates, let's say someone takes an assignment over in the UK, for example, and they're working there, a lot of times it gets overlooked. You may have abandoned your state residency, but from a U.S. standpoint, you're taxed on worldwide global income with potential offsetting tax credits for foreign taxes.
Okay, we're going to wrap up a little bit here, but before we do, I want to know mistakes. What are common mistakes that companies make when expanding into the U.S. market? Oh, then maybe from practical experience, did you can you pinpoint one or two mistakes that maybe could act as some advice to others?
I don't know. I think that I am on mute. 1 second.
No, you're good.
Yeah.
You were good. We all make mistakes, is what I was saying.
Okay. Okay. So well, at least one mistake. Okay. Well, two mistakes. First, don't initiate your business before the corona is started. Okay. No. Now seriously, the location is when you refer to B2B. So we are unfortunately not Monday.com, right? So we actually have to go from one retailer to another and to supply a project that has the hardware and the communication and some infrastructure. And from location standpoint, New York is probably for sure not the one to be in. So according to the field of expertise of your company, you should select smartly the location, your landing location, okay, where you should be based. And that's, it's more than having an entity in Delaware or in Maine. It just, where the people should be, where you should recruit your team, and so on. And this is something that we felt, but we didn't know. Okay, so we started in New York, and after a while we saw that, okay, it is not progressing, in the cadence which we would love to have. Okay, so we moved the operation, and we moved the focus to California, and so on. Okay, so that just waste of money, and as you know, New York is very expensive. So
that's good advice. Okay. Ed, what do you think? Common mistakes?
Yeah, just from my perspective, I think not coordinating the tax structures from a foreign and U.S. standpoint, setting it up as a corporation where the owners could be subject to double taxation, making sure that, we're being able to flow taxes back to claim foreign tax credits where appropriate. And then also compliance issues. We want to make sure that the businesses are in compliance with the maze of different taxes, sales tax, payroll taxes, corporate income tax, et cetera.
Fernando, what do you think? Common mistakes that you see?
Yeah, I agree with Ed's comment. You really need to integrate the foreign entity type and the U.S. entity type, or else you may be subject to double taxation, like the example I gave, where a foreign individual forms a U.S. company, and when they get a distribution, they're not able to credit the U.S. corporate tax paid. That's a really, really bad situation, but we see it. It still pops up because people didn't get advice on the front end, or they just didn't think about it. Another one is probably, setting up an entity in the US when really you didn't need one. You could have just marketed from offshore, especially if you're providing services or selling products online. You really should think twice whether you really need a US entity. And in some cases, you really do need one, either to drum up sales or otherwise, but companies should really think, how long can they function without setting up a US entity? And probably another big one is transfer pricing. Like I said, a lot of people think of transfer pricing as a burden. Why is that? Because the tax laws of each country require you to maintain a transfer pricing study to support the intercompany transactions. And people see that as a burden, it's a cost, but it can also be very, very advantageous because if you think about the transfer pricing ahead of time and you move your people, your assets, activities in a strategic way, then you could maximize income, like I said earlier, in a low tax jurisdiction and have the expenses in a high tax jurisdiction. And one final point I'll say about IP, I worked in Silicon Valley for several years for the high tax software online companies, many of them startups, and they were all moving their IP, at least the foreign rights to the IP, out of the US to Ireland, Switzerland, the Netherlands, even Cayman and Bermuda in some cases. And why did they do that? Obviously to lower the tax rate on that income, but more importantly for many of them was that it lowered the effective tax rate. And that was very important for raising funds. If they wanted to go public, or if they were public, then the value of the stock would climb as the effective tax rate went down. And so that's something even non-public companies should think about. The value of your company is going to be greater if the effective tax rate is low. And that's why it's so important to think about the ownership and management of IP and to make that really tax efficient.
Yeah, I'll just say one big mistake that I see all the time is people or companies trying to do all of what we just talked about without a good accountant and lawyer. Yes, said the lawyer. So yes, I think it's really important that you have good people trying to help you. I want to be mindful of time. I know we started a little bit late. Any questions, final thoughts from Oded, Ed, Fernando, Smadar, anything? Good.
No.
I would just conclude by saying, to your point, David, I think it's important that business owners have good sound tax advice, legal advice, et cetera. Absolutely.
Agreed. It comes back to haunt you in the worst ways, especially for startups, right? Like, starting your own corporate entity on like LegalZoom or something like that. That's a whole nother presentation. Like there's definitely some legal and tax issues that are not contemplated, and just could be a lot to extricate yourself from when it's clutch time with your investors or what. So just keep.
Sivan, did you have a question?
Yes. No, she had a comment, but Sivan, did we address it?
Yeah.
Okay.
Yeah, I think that she was giving a high five. That's
No, it was applause.
David, Bob Mayer. I'm a partner at Prager Metis.
Hey, Bob, how are you?
I'm good. One of the things that I want to make sure everybody on the call knew is that we do a lot of international business. And when it does come to the United States, our client accounting service area actually works well with the partners and with the foreign entity and creating the banking situation, getting ID numbers, sales tax, as well as setting them up on zero if they're an international entity, with, more than just the US that we'd be handling, because we also have our London office doing some client accounting services. And I lead the CFO advisory group, and we work also with some of the foreign entities just to help them with expansion terms within the United States, and somewhat just creating a level of management that they don't need to duplicate here, that we can provide as a firm. So I just wanted to add that. I'm not sure who's on the call other than some people I saw, so I appreciate it.
Thanks, Bob.
I just wanted to jump in real quick, if I may, 50 seconds. Bob Mayer and I work on the, in addition to taxes and Bob's CFO work, but also I mentioned earlier in the presentation about the SBA lending, the Paycheck Protection Program, and foreign ownership of U.S. companies. The U.S. companies could have been eligible to borrow, and if you did and need assistance with that, certainly I'd like to think we're very well versed. We go 100 miles an hour every day helping clients out with the various aspects of these programs. So I thought I'd put that out there as well.
Appreciate that. So in the interest of time, we're gonna call it. Thank you for joining us. We recorded this, so we'll post it on. We'll market it and post it as well. So if you missed something, you can always catch it again. Thanks to Ed, Fernando, Oded, Smadar. I appreciate it. Thanks so much.
Thank you.
Thank you, everyone.
Take
Thank
care.
you. Thank you, David.
Bye.
Thank you for joining
Thank you.
us.
Bye now.
Bye.
Bye-bye.